morning and welcome Miss Janita and to those who are watching our video about a discussion between Malaysian law students and UK law students. Today our topic will be about contract law. For that we have prepared a situation between a wife and a husband and a bank, and between two friends and a bank. We will find out whether or not the wife and the friend can they raise undue influence to have their contracts with the bank voided. Alright, firstly, what is undue influence? To put it in layman terms, undue influence is when a transaction or an agreement is made by pressure by one party. Like the one person, he did not go into the contract of his own free will. He was given pressure or dominated by the other party. Therefore, I have prepared a case law which I will be giving you more insight about how undue influence works. The case is about Barclays Bank and O'Brien. Alright, in this case, the husband and the wife went to bank to get a loan for the husband's capital for his business. The husband promised the wife that the deed has a limit on it and it will not go more than the limit. So the wife trusted him and used their house as security for the bank. It turns out that the deed was unlimited and that the husband misrepresented the deed to the wife. Now, the wife has sued the husband for undue influence, that she did not went into it willingly and that she was given pressure by the husband. The courts have held that the wife has won the case as there was undue influence in it. Even though they are husband and wife, and the wife has placed faith and trust in the husband for their financial matters, as she has done that in the past, the husband can still be held liable for undue influence as he knows the true facts of the deed and he withheld information from the wife, abusing her trust that she placed in him. As undue influence also goes through abuse of relationship, like you abuse someone's trust and faith in you. Therefore, this is all for my part, and I'll give it to our Malaysian law representative, Ms. Lin Lau Yi, who will continue an in-depth explanation of whether or not the wife can held undue influence. Ms. Lin Lau Yi, you have the floor.
So thank you, Ziliang. So as referred to the scholar Nuratina Ahmad Sharif, and also in reference to the case of Polygram Record Sandra Berhad and the Search, and the case of Tengku Abdullah and Muhammad Latif, the court contends the principle of undue influence as explained in the section 16 of the Contract Act 1950. In substance, adopts the English position. So it has been recognized that section 16 does not differ from English law. So the section 16, subsection 1 of the Contract Act 1950, it has stated that in order to establish undue influence, it must be proven the wrongdoer was in a dominant position in his relationship with the complainant, and the wrongdoer used that dominant position to obtain an unfair advantage from the complainant. So whether Chandran was in a position dominating the will of Devi, because Devi has to prove there is actual existence of Devi reports trust and confidence in the wrongdoer Chandran to satisfy the class 2B of undue influence. According to Dr. Sheikh Ahmad Al-Sagov, in his book, he states a span of time is required for one to have undue influence over the innocent party. The section 16, subsection 3 of Contract Act 1950, the Act has clearly indicated the proper order in establishing undue influence. The first thing to consider is the existence of the special relationship. Devi has signed the documents and charged her house to the bank for her husband. So this action indicates there is a relationship of trust and confidence among them. Even if the dominant position is proven, the victim must show or must prove the wrongdoer had secured an unfair advantage from the innocent party, in reference to the case of Ibrahim B. Musa and Bahari B. Nayang in the in the year 1990. The agreement between Chandra and Devi is disadvantageous to her as there is a risk of losing her house if there is default payments to the bank. Further, there was no independent legal advice for Devi at the time of the contract is made, as she only had a private meeting with Chandran's solicitor, who also failed to explain the risk of the transaction. Therefore, Devi satisfied the requirement of Section 16, subsection 3 of the Contract Act. The burden of proof shifts to Chandran, so Chandran had to prove the contract was not induced by undue influence. The bank manager had instructed Devi to look for independent advice after he gave the opinions of the offer by Chandran to Devi. The creditor will be put on notice that the manifest undue influence exists where the debtor is a non-commercial party. It would be perfectly natural of a wife to wish to support her husband's business, but the bank will have to make sure that steps are taken to ensure that to stand surety is taken freely. According to the case Sultan Bang Berhad and Abdul Rauf bin Rakinan, the High Court held the case more ready to find that a husband had exercised undue influence over his wife in the Class 2B cases. The court held that where a wife is influenced by the husband to stand surety for her husband's death, then she has the equity to set the transaction aside. Notably, Devi can only enforce her rights to set aside the transaction if either the husband was acting as the bank's agent or the bank has actual or constructive notice of the wife's rights. The bank manager has constructive knowledge of Devi's rights as he has known Chandran for many years and should have known that Chandran and Devi are in the husband and wife relationship. There is deemed to be constructive knowledge of any impropriety that the bank should dispel. The bank knows this is disadvantageous to Devi and should put on inquiry before she agrees to sign the contract. Further, the nature of the guarantee was not explained to Devi, so the court is likely to allow for Devi to set aside or maybe able to rescind the contract and restore back before the contract was signed. Now I'll pass to my group.
Thank you, Lynn, and I'll be talking about Chandran and Fuad in reference to Malaysia law. The requirement that both parties enter into a contract with free and informed consent is one of the core standards of contract law. Under Section 13, Contracts Act 1915 stated that two or more persons are said to consent when they agree upon the same thing in the same sense. However, under Section 10, subsection 1 of the Contracts Act 1950, stated that an agreement is a contract only if it is made by the free consents of the parties. It's possible that Fuad's regret won't be enough to make the contract void. He may be able to contest the legality of the contract, though if he can show that Chandran forced, bribed, or misled him into giving his shares as security. Since Chandran persuaded Fuad to stand surety, therefore there is no free consent. The existence of the special relationship is the first factor to take into consideration when establishing undue influence, as stated clearly in Section 16, subsection 3 of the Contracts Act 1950. As over the years, Fuad had often sought investment advice from Chandran as he felt that Chandran was well versed in business affairs, which indicates that there is a relationship of trust and confidence between both Chandran and Fuad. In the case of Kanapa Chattiar versus Pusaturai AIR 1920, it was stated that Section 16, subsection 1 requires proof of both of its elements. The other party was in a position to dominate the other's view and that one party exploited its position to gain an unfair advantage over the other. It was acknowledged that Section 16, Section 16 does not differ from English law. Was there any lack of understanding from Fuad? It's essential that Fuad comprehends the dangers and ramifications of offering his share as security. It's crucial that Fuad was informed of the dangers by the bank's internal attorney, it might be more difficult to contest the contract on the grounds of Fuad's ignorance if the bank took reasonable efforts to guarantee that Fuad understood the terms of the agreement and the risks involved. One component that every contract must have is consideration. The contract might be more enforceable since Fuad got something in exchange for offering his share as security, like a cut of Chandran's company profits. The question here is whether Chandran exploited his position to gain an unfair advantage and whether Chandran was in a position to dominate Fuad's will. Fuad had met the bank's in-house lawyer who carefully explained the risks involved to Fuad. Therefore, the first lim domination of will not proven in reference to HSBC and Psych United Leong Enterprise and Annual 1993, and the bank had no undue influence over Fuad. The second lim, unfair advantage, was not proven as Chandran promised a share of his business to Fuad in return for the loan, in reference to Bahari bin Nayan and Ibrahim bin Musa 1990. No undue influence was proven, as both elements of Section 16 subsection 1 was not proven. The burden had not shifted to the influencer to disprove undue influence. Therefore, the court will enforce the contract and Fuad will not be able to set aside or rescind the contract. Thank you, and I'll pass it to Gugu.
Alright, thank you to our Malaysian law students for that wonderful insight on Malaysian law. Now, we invite Miss Gugu, the UK law student, who she will be giving her insight and viewpoints of the English law on this two situation. Miss Gugu, you have the floor.
Thank you all for having me. It is such a great honor to be here today. I will be advising Devi on the English position. Firstly, the contract is between Chandran, Devi, and the third party, which is the bank. It is important to note that husband and wife cases cannot fall under special relationship. This means that this case between Chandran and Devi is a 2B case. A 2B case that involved a husband and a wife. The case of Royal Bank of Scotland and Etheridge also established that to raise a presumption of undue influence, it must be proven that there is a relationship of trust and confidence, as well as a transaction which calls for an explanation. Devi was advised by the bank to seek independent advice. Instead, she had a meeting with Chandran's solicitor, who failed to explain the risks to her. However, by signing the documents out of free will, this reflected a relationship of trust and confidence. Under presumed undue influence, it is evident that no one wants to enter a contract if it does not benefit them. In this case, Chandran did promise to share his profits with Devi, so this is a contract that will benefit her as well. This means that he can rebut his presumption as she is willing to use her house because of the shared profits. Devi can rescind if she proves that there is a disadvantage, the bank has knowledge or the bank is put on inquiry, and an entrusted solicitor should express full satisfaction that both parties give consent. There was no actual knowledge given to Devi, but constructive notice, as she was advised to seek for advice from her own lawyer, but she decided to use Chandran's solicitor, who failed to explain the risks to her. Under the English position, she will be able to rescind the contract, as she was not informed of the risks. Unfortunately, the other lawyer from the UK was unable to join me today, so we will give her a call so that she can give us her advice to forward on the English position.
Hello, my name is Haya Kodoe. Unfortunately, I couldn't be there in Malaysia, but it is such an honor to be one of the lawyers to advise in the English law. Thank you. So to begin with, a contract has to be enforceable. So an agreement to the terms must have been freely given. Well, the doctrine of undue influence will protect a party to a contract where some form of improper pressure has been applied. The parties involved is between Fuad and Chandran, the third party, which is the bank. It was once stated by Cartwright that undue influence is where the circumstances of a contract in the context of the relationship between the parties enabled the court to presume that the influence had been exerted. So, although it could not be affirmatively proved on evidence. So, the presumption may arise automatically from the type of relationship, which is class 2A, or it may be necessary to establish the specific relationship between the particular parties is such to give rise to the presumption, which is class 2B, a position leading to a result from a relationship of trust and confidence. Fuad and Chadrick have a past of history, placing trust and confidence in each other. So this was over a few years back when Chadrick had bought some sort of investment advice from Chadrin, as he felt that Chadrin had a well-versed knowledge in business affairs. There was no special type of relationship between Fuad and Chadrick, which leads us to class 2B of the presumption of undue influence. So in the case of the Royal Bank of Scotland versus Ettridge, the House of Lords stated that the presumed undue influence necessarily involves some legally recognized relationships. These legally recognized relationships are merely the relationships within the category of class 2A of the presumption of undue influence. So as such, just being a long-term friend is not known as a legally recognized type of special relationship. Having established that Fuad reposed trust and confidence in Chadran, it would be necessary to show that the transaction concerns called for an explanation prior to Ettridge's case. A claimant would have to demonstrate that they had suffered a manifest disadvantage. So Fuad could potentially lose his shares in the public company. But then manifesting disadvantages are no longer a legal requirement for establishing undue influence. But it does sort of become useful because it will be used as evidence. So in the case of Orchard versus Skinner 1887, which suggested that the transaction should be capable of an explanation on the grounds of friendship. So it could either be a relationship, charity, or other ordinary motives. But then Fuad using his shares in a public company as a security for a friend's debt is not the usual type of transaction between friends. But then Chadrin does appear to have taken advantage of Fuad's trust in him and used it as an advantage for himself. So Chadrin can rebut the presumption of undue influence if he can demonstrate that Fuad acted of his own free will. But then following the case of Ettridge, any creditor, once having constructive notice of potential undue influence, will make the contract voidable due to influence unless they can demonstrate that they took reasonable steps to ensure that the other party, in this case which is Fuad, had given the agreement on their own free will. So the bank, to protect its own interests, would have to verify that not only did such a meeting take place, but also the issues were also being discussed. Chadrin and Fuad had met the bank's in-house lawyer, who carefully explained the risks to Fuad in Chadrin's absence. So Fuad had then signed the documents charging his shares to the bank, meaning he signed the documents out of his own free will, which in conclusion, Chadrin can rebut the presumption of undue influence. Fuad would not be able to rescind the contract as he was already advised about the risks by the bank's in-house lawyer.
Alright, thank you, Miss Harriet, for that wonderful explanation, and to our Malaysian law students and Miss Gugu from UK. I'm sure that all of you, after watching this video, your knowledge about undue influence on when you can raise it as a defense should have increased. Alright, to wrap it up, I shall be giving a comparison on the Malaysian law and the English law position on the difference for undue influence. In Malaysian law, Section 16, subsection 1 on the Contracts Act 1950 requires the claimant to show that one party has abused their relationship or abused his position in order to get an unfair advantage. This is the main difference for Malaysian law and the English law, where it requires the claimant to prove that the other party has received unfair advantage in their contract or agreement. Whereas in the English law position, mainly look at the two elements such as the state of mind and the conduct, where they rely on whether or not the claimant was in a good state of mind and willingness, and whether or not the defendant did he show any conduct such as pressure and threats. Alright, before I wrap up the entire thing, I should talk about what remedies will you get after raising undue influence as a defense. The primary remedy is that your contract will be voided, like there will be no contract made if undue influence were found in it. The next one would be recession, where if undue influence found, the claimant can choose to set the contract of both parties back to its original position. Now there is a difference for that in Malaysian law and English law. In Malaysian law, for recession to work, if one of the parties have already received benefit from it, they will need to give compensation back to the other parties, as the court will hold that deemed correct in order to set both parties back to their original position. However, in English law, the courts will try their best to set both parties back to original position, and if the thing was like paid or bought for a very long time and it was used already, like there might not be compensation for either parties. So that is all for our wonderful discussion about contract law, undue influence. I hope you all have a good time watching this video and stay tuned for our next discussion. Thank you.